So the topic of today is probably, if this was the game show called Family Feud, and it was the top 5 questions that divorce lawyers are asked, this is probably one of the top 5. What is the legal status of a common law relationship? Or oftentimes the way it's asked is, do I have to pay or am I entitled to receive any money, given that our relationship is a common law relationship? Yes. And so that question then obviously leads to the next question, which is, what is a common law relationship? And many of us forget those words that we use. In other words, what is this thing called common law? What is even that? Is it just the word common, like commonplace or common location? We have things in common, so therefore we're common law. No. It's none of that. What common law really means is that it is not defined by legislation or by a statute. And that is the other form of the law in most developing worlds, like Canada, United States, and so forth. We have statutory laws, which is established by legislation. And then we have laws that are established by judgment. And that is sometimes called precedent, sometimes called case law, and sometimes called common law. So that bark is for me to open the door to let the dog out. I'll be right back.
Okay, well, I was debating whether I should put mine in another room. It's unfortunate but I have somebody who plants urns for me, and I think they're just right at my door right now planting the urn. So of course the dogs are going crazy. So I may just slip into another room here where I can close the door. So because I have a feeling they're going to be barking for a little bit. So
okay, so I will take over until you manage
all right,
your poodle family. Okay, so we've established that the word common law spouse includes the words common law, and we've established that the reason they use the words common law to define a spouse or a relationship is so that it is different than the legal or statutory or legislative definition of a spouse. And this is where things get a little funny. So for many, many years, people would say, you know, I'm not married to him or her. He's or she's my common law partner. In other words, they've become a legal union simply by virtue of them sharing a home and sharing a life and sharing children. Well, the common law the statutory law has caught up with the common law, meaning now, and for certainly the last 20 or 30 years, we actually don't even have to use the word common law anymore, although people still use those words, because Part 3 of Ontario's Family Law Act includes what's called the expanded definition of a spouse. So Part 1 of the Family Law Act deals with property rights. And under that category, only people that are married to one another have property rights under Part 1 of the Family Law Act. Part 2 of the Family Law Act deals with matrimonial homes, which is a right that's only accorded to those that are married, like in Part 1. Part 3 of the Family Law Act deals with support obligations, supporting children, supporting parents, and of course supporting spouses. In Part 3, we have the expanded definition of a spouse, and that now includes people who have a child in common, whether by birth, adoption, or people that have lived together in a relationship of some permanence for no less than 3 years. You heard it right, viewers, no less than 3 years. And that is what people call a common law spouse. Is it really coming out of common law? Nope. It's coming out of Part 3 of the Family Law Act, which is not common law, which is actually a statute, which is actually legislation. Yet people continue to use the phraseology, he or she is my common law spouse. Okay, so let me pause on that and ask you, Leanne, because you're far more connected with pop culture than I am. Why are people still using the word common law spouse?
You know what? I just think it's a term that, you know, it's easier to differentiate a relationship from like one of marriage. And so rather than saying, like if you say they could say their partner and then you don't know if they're married or, you know, what the relationship is. And there's nothing wrong with that. But I think
well, how about this? How about if somebody showed up to a party and said, who's that with you? And the answer was, oh, that is my Part 3 expanded definition of a spouse under the Family Law Act.
Well, that would be an interesting answer.
My own question. Just say she's my common law spouse.
Yeah, I think that would be a very interesting answer. So yeah, and common law spouse sounds more permanent than girlfriend or boyfriend. So maybe it's giving people feeling like they have some sort of status of, you know, that beyond just being a boyfriend or girlfriend. Right.
And so just like when people say they are getting married, people go, well, when are you getting married? And then when people get married, people say, well, when are you going to have children? So there's always the people asking, well, what's next? So I think there's a large population of people that still believe that being common law is a precursor to being married, or they haven't really gone as far as tying the knot. For lack of a better word, I don't know why we use the word tying the knot, because arguably they're tying the knot when they're common law too. So, so now let's talk about the actual rights. So I'm going to actually let you have a little bit of the microphone on this one. And why don't you tell our viewers, what happens when you are a Part 3 expanded definition common law spouse, whether you have a child in common or you are together for 3 years or longer?
Okay, well, a couple things happen, and there's a lot of misconception surrounding this, and I think that's because in the United States, the rights are different in different states for common law partners, and so people watch American movies and TV, and they have this idea that they have property rights, and in fact, as Steve was just discussing with respect to the Family Law Act, you in fact don't have statutory property rights when you live in a common law relationship. So that is one of the key differences. And so just first dealing with support, as Steve mentioned, you're covered under Part 3 of the Family Law Act. So you have, if you meet the definition in there that you've lived together for 3 years, or you have a child, then you may be entitled to spousal support. If there's children, there's definitely going to be child support. And so how you're treated there would be very similar to if you were married to your partner. But Section 1, Part 1 and Part 2 of the Family Law Act are going to treat you differently because with respect to a common law relationship, well, I'll call it that, you don't have property rights if you split up pursuant to the statute. So what that means is that any assets that are in the wife's name, and she had them in her name prior to marriage, she had them in her name, not prior to marriage, prior to moving in together, and she had them, in her name, whatever assets she had in her name on the date of separation, which is the key date, those are hers. So if she, if you live in a home together and the home is in her name, then depending on, there's some always gray, but on the home, if it's in her name, then title usually rules. And so again, as I say, this is a very general explanation because there are other issues that can be raised there, but generally title rules. Her bank accounts are going to be hers, her debts are going to be hers, and same thing for the husband. So whatever's in his name on the separation date is going to be his. And if there's a joint account or if you own a home jointly, then it's just split in half. But otherwise you don't have, whereas if if the husband and wife were married, and they were married, say 20 years, and the husband had a pension, and that pension was growing, the wife, when there's an equalization done of their net family properties, she might be entitled to a portion of the pension in an equalization payment. If you're common law and you're not married, that may not be the case. But there's arguments that you can make to change that, but just sort of on its face, you would not be entitled. You'd have to prove certain things in order to be entitled that you don't have to prove if you're actually legally married. A second important, or I guess it's a second important difference, is that the matrimonial home in marriage is a very important asset. And, a lot of people are aware that the matrimonial home, is something that it's not an excluded property. So if somebody owned the home before they got married and the parties move into the home together and that's where they live, it's treated differently. And one of the key rights that married people have with the matrimonial home is a right of possession. And so that means that if you separate and you're married, you can't just kick the other spouse out of the home, even if it's in your name, unless you go to court and get an order for exclusive possession, which is hard to do, and you have to show something like severe abuse and things like that. Whereas if you're common law and you're not married, if the house is in the wife's name and she wants the husband out, he doesn't have a right of possession the same way. And when I say husband, I'm getting the terms a little cross here too, but the common law husband, he has to leave if that's the case. He doesn't have a right of possession. And so that's a very different. You see common law people, being kicked out very quickly, and that can be a bad place to be. So that's a very general summary of the difference.
And that's very good, and you've done a good job explaining that to our viewers. And just for those that are trying to follow the bouncing ball, I want to be very clear about this. I actually think these laws are antiquated, unfair, and need to be modernized, because quite frankly, if you live at a house and if you walk out your front door and the people to the right have been together for 20 years and have 2 children and own that house, and the people on the left have been together for 20 years and have 2 children and they're on title, but they don't have a marriage license because they are, wait for it, common law. The law sees those 2 families very differently. And the outcome, if those 2 families split up, is dramatically different. The amount of legal fees that those 2 families will spend are dramatically different. And just so that we're clear, the married people will probably spend less in legal fees than the common law people. And I'll explain why in a second. But as it relates to their rights and their obligations pertaining to the children, they're exactly the same. Where the difference is, just like you said, Leanne, is when it comes to subjects such as property, home ownership, and spousal support. Now, like we said, for the couple that lives to the left and to the right, they've been together for 20 years, their rights are going to be the same because they exceed 20 years together. They exceed 33 years together, and they have children in common. So the spousal support rights, the child support rights, and the parenting rights are going to be identical. However, the property rights are going to be dramatically different. So about 10 years ago, a couple by the name of Kerr and Baranow didn't like that answer. They were common law. And as a result, they went to court, and Ms. Kerr lost. And so she appealed it. And it went all the way up to the Supreme Court of Canada. And the Supreme Court of Canada said, it's really not fair for her to be treated differently. So we're going to give her a remedy. We're going to give her a remedy that is not the remedy that is available to married people. We're going to use a different way of getting there. We're going to say, did she contribute? Did she have a role? Did the growth in assets have anything to do with her? And the answer was yes. So the Supreme Court of Canada said, well, did the common law husband get enriched? The Supreme Court of Canada said, yes, he was enriched. And the Supreme Court of Canada asked, was she deprived in any way? The Supreme Court of Canada said, yes, she was deprived. And then the Supreme Court of Canada said, well, if she was deprived and he was enriched, Was there any reason for it? Was there any justifiable reason? Nope. No justifiable reason that he got more, she got less. So the Supreme Court of Canada said, well, that's unjust enrichment. That's not fair. We're going to give this lady some money. We're not going to use the same scheme for married people, but we're going to try to match it as close as we can. And the Supreme Court of Canada called this concept a JFV, joint family venture. And so ever since the Curran-Baranow case, when I have a common law spouse come in my office and say, everything was in the other person's name, or most of the assets were in the other person's name, and look what I ended up with, and look what she or he ended up with, I look at the case through the lens of Curran-Baranow to determine whether we could build a case called a joint family venture, which takes me right back to the point that I made, that when you leave your house, the couple who splits up to the right, who are married, are going to spend less in legal fees than the couple on the left, because the couple on the left have to either make a case for joint family venture or defend a case for joint family venture, which is extremely expensive, whereas the couple on the right, all they got to do is hold up a marriage license and say, we got married. By virtue of the fact that they hold up a marriage license, there's an automatic expectation and legal presumption that all of those assets are going to be equalized with certain exceptions and parameters. And that is the difference between the common law relationship and the married relationship under current Ontario law, which, like I said at the beginning, really unfair, really antiquated, and really needs to be modernized, and maybe they will. I should add, the other day I had a client say to me, we're common law, and we were together for a very long time, something like 40 years. And they have no assets and nothing to speak of. The only reason I was consulted was because during the years that they both were working, he earned way more than she did. Now they're both on pension. They're both retired. And in fact, they're more or less poor. They're living off of old age security and CPP. So there's no assets. There's no private pension. There's nothing. But during the years of marriage, he earned more than she. What does that mean? Not during the years of marriage, during the years of cohabitation. So what does that mean? That his CPP payments per month are higher than hers. So then the question became, can she equalize his CPP income? Well, she could try to by way of a spousal support claim, but my research came to show that federally, and remember, the laws that we told you about, Part 1, 2, and 3 of the Family Law Act, that's provincial legislation. Federally, she can apply to have...
Oh, your voice black went out there.
Her to, federal law allows her to equalize the CPP credits even though they're common law by legislation, whereas Ontario family law doesn't. So there are so many inconsistencies, or what we lawyers call a lacuna, in the law that doesn't make much sense, because the nature of a common law relationship is no longer common law. It's actually in the statute. It's just that it's in the statute only as regards to property, not as regards to the other rights and remedies. So, long short, for the purposes of our viewers, we've got people that are married and people that are cohabiting as spouses. And if they cohabited as spouses for 3 years or more in Ontario, or if they have a child in common, even though they may not have lived together for 3 years or more, but they are in a relationship of, again, the legislation calls it a relationship of some permanence, then they are entitled to spousal support rights. If they are in a common law relationship, whether they meet the 3-year or the child in common rule, there are not any automatic legal presumptions to property rights or to the matrimonial home. And that is where we currently are in the state of the law for people that are married versus people that are not married but call themselves common law.
Now, I have a question that may be going through some of the listeners' minds that I think we could address is, if somebody came to see you and they said, you know, that they are about to move in with their boyfriend or girlfriend, or they're already living with their boyfriend or girlfriend, and they have some concerns about the things that we're saying about the differences with respect to property rights, what advice would you give them? So not advice, but what information? Because I want to stress, we're not giving legal advice here. We're giving legal information.
So that is the $1 million question, which happens to be the typical price of a condo in Toronto, $1 million. And so when people who are dating either own a condo or want to buy a condo and they're dating and they want to bring their new girlfriend or boyfriend into that residence to live with them, oftentimes they somehow find you and I to ask, what should we do to protect that asset? And the answer, generally speaking, is if you want to ensure no potential loss in light of a potential breakup to the asset that you've created, number one, don't have a boyfriend or girlfriend. If you're going to do that, then do it, but don't live together. But if you're going to live together, don't live in your condo, live in the other person's condo. But if you're not going to do that, then get a cohabitation agreement signed. Have a cohabitation agreement prepared by a lawyer that basically says that condo and, quite frankly, your income is for you to keep and not to be shared should the marriage, or excuse me, should the relationship end. And that is, of all of the different levels of risk, if you're going to accept the risk of being with someone and having that person live in a condo or home that you own, then you do a cohabitation agreement. But, you know, the reality is, I had a case where the person was in that situation, and after the advice that I gave, they decided to not move in together, but move into a new place together. In other words, the condo that she owned, she was going to move out, rent it out, keep that as her investment property, and then move into a new place. I'm not sure if they bought or rented together, but that's a way of preserving her asset without having to go the route of a cohabitation agreement.
Now, I had a client recently where his girlfriend was moving in with him, and he had quite a bit more money than she did, and so he wanted me to draft a cohabitation agreement, so I did. And we gave it to her and advised her to get it, you know, to go get independent legal advice, which she did. And the lawyer that she got advice from told her that it was, you know, very much in his favor, and that he recommended that she maybe shouldn't sign it. So she came back. So the lawyer responded that back to me, and I said, well, you know, what would she like changed? We can, you know, we can negotiate some things here. And it ended up that the couple ended up breaking up over this agreement, unfortunately. And so he recently advised me that, you know, they had broken up. And so, and I don't say that to people to be wary of getting an agreement, because I do think getting a cohabitation, a marriage contract, all these sorts of things can be very helpful and are a really good idea. And it's part of, I think, having good communication in any relationship is being able to discuss financial things and understand them and be fair. I mean, I think being fair is a really important piece as well. But that's something I had recently, and I just recently acquired a client where it's interesting. They have potentially a joint family venture. So we're entering into that, you know, area where everything's in the name of one party. And my client has nothing in her name, but they run a business on a property, and she's put a lot of, you know, effort and work into this business, blood and sweat and tears, so to speak. And she has paid for some things, although a lot of the stuff was paid for by the other party, who is much wealthier. So it's going to be interesting to see how that.
Yeah. Going back to your comment about the first of two clients, the cohabitation agreement that ended up not getting signed because they broke up. You know, Phil Epstein, may he rest in peace, he used to say that people should do prenups and cohabitation agreements no later than 6 months before when they start living together or getting married. And there's a lot of wisdom in that because two parts. One is it's like doing a will. You don't want to think about death, but you can't help but think about death when you do a will because you're thinking about who gets everything when you're no longer there. Well, similarly, doing a marriage contract, a prenup, or a cohabitation agreement is really about what happens in case you two break up, which is not a very positive thing to think about when a marriage or a relationship is just about to start. But it's a responsible thing to do, no different than it is a responsible thing to do a will, no different than it's a responsible thing to do to buy life insurance if you have dependents, or to buy car insurance, not because you want to have an accident, but because in case you do have an accident, you are protected. This is exactly the same thing. But what I would say to our viewers about the subject of cohabitation agreement, marriage contracts, and prenups is this. It is a device that causes one's values to be exposed. And when those values are exposed between the two spouses, partners, girlfriends, boyfriends, etc., it causes a review of those values. It causes those people to decide whether they have the same or different values. And it may very well be that one person really did want to be with the other person because of wealth. And when that wealth was not going to be available should they split up, that was the thing that broke them up. That's a simple explanation. It could be that the person that was asked to sign a prenup or a marriage contract really never was interested in the money, but now figured that the person that's asking him or her to sign it is all about money and all about protecting their money, and they don't like that value. Mm-hmm. But the bottom line is these agreements, these domestic contracts are really effective in outing one's values. There are still till today people that are extremely wealthy and make a high level of income and get married without domestic contracts. And they do that with their eyes wide open because they do not want to taint that relationship by even foreshadowing the end of the relationship. And then there are other people who have very good advisors, like their parents or their financial planners, telling them, you really do need to do a prenup or a marriage contract or a cohabitation agreement. And that's where we come in. And when we do come in, the Leannes and the Steves of the world, we are extremely sensitive about not allowing the development of this document to cause a rift between the spouses, and we exercise tremendous discretion and care, even in terms of scripting how they are to communicate about the document with their soon-to-be spouse. So it does not necessarily mean that if you consider doing a domestic contract to protect your income or your assets, that you are effectively bringing about the end of the relationship. It's really about doing it the right way, doing it early, doing it with discretion, and doing it with integrity.
Yeah, definitely. So I think on that note, we can wrap it up. So thanks, Steve. Thanks to our viewers for tuning in. And we'll see you here again next week.
Be well. Bye, everybody.
Bye, everybody.